The status quo in the VA disability world for, I don't know, 30 years, whatever it was, a long time, was the legacy appeal structure. Now what that was is where a veteran files a claim. If it's not a favorable decision or is not as favorable as you might want it to be, you can appeal that. The starting point under the legacy appeal structure is you have to file something called a notice of disagreement within 1 year of that decision that you're not happy with. Now what we have here is we're at a dichotomy, we're at a crossroad where the VA has started a sweeping legislation reform called the Appeals Modernization Act that started February 19th of 2019. Now this new Appeals Modernization Act kind of turns things on its head when compared to the old legacy appeal structure. What the Appeals Modernization Act does is they say when you get a decision, you have one of 3 separate appeal paths you can take. Now the first path is something known as a supplemental review. That presupposes that you have new and relevant evidence to give to the VA. Let's say you had 5 conditions, condition 1, 2, 3, 4, and 5, and you want to appeal conditions 1 and 2 under a supplemental claim because you have a doctor's note saying that it was caused by the military. But conditions 3, 4, and 5, you really don't have new and relevant evidence. You just think they applied the facts wrong to the law. You can actually split the lanes. You can say conditions 1 and 2, I'm going to go down the supplemental appeal lane. But conditions 3, 4, and 5, they got it wrong, and I want a higher level review. So higher level review is the second lane you can do. The higher level review is saying I want a senior level adjudicator who has a degree of authority over the initial adjudicator to give a new decision based off a review of the previous decision that was made. They then issue a full decision letter out to the veteran implementing the higher level review. They call them DROCs, Decision Review Officer Centers, I believe. So the third lane on an appeal under the Appeals Modernization Act would be going straight to a board judge. You can say, no, this is wrong. I don't want to play I don't want to play the VA game at the lower level. I want my day in administrative court. I want my day in court. I'm going to go see a board judge and get in line right now. Now, in most cases, we wouldn't advise that. We like to have as many bites at the apple for our clients as possible. But we found there's quite a few different type of claims where only a judge is really going to issue a favorable decision. So again, the Appeals Modernization Act offers one of 3 lanes. The supplemental review, which is in the lower level adjudicator with new evidence, new and relevant evidence. The higher level review, which is going to be a more senior adjudicator, or going straight to a board judge. In theory, you can keep an appeal alive, what they would refer to as in perpetuity, forever, going back and forth from a higher level review to a supplemental review, to a higher level review, to a supplemental review. So the point being is you can go back and forth and you can just keep getting new medical doctor opinions as long as you have enough doctors. Compare that to a Thailand, Vietnam era veteran who has worked in the perimeter but doesn't have proof and his testimony to a judge is going to be critical. We probably won't go back and forth between the supplemental and the higher level review. Instead, we're going to say we want our day in court now so we can get this over with. So hopefully the board judge docket speeds up. That's a real problem right now as you're looking at 2 to 4 years to see a board judge for a hearing right now. Under the Appeals Modernization Act, it should speed up. On the whole, the Appeals Modernization Act is likely going to be a favorable thing to veterans, but you need a practitioner, an attorney, who knows how to navigate it, and that's critical because it's more complex than the legacy appeal structure. There's instances where a veteran who was already in the legacy appeal structure, they have the ability to opt in to the new jurisdiction, which is the Appeals Modernization Act. Just because they have the chance and opportunity to doesn't mean they should. They might already have a favorable decision that's pending and they don't even know it because the medical opinion and doctor report is of record, but they just haven't issued a new decision yet. So it can be dangerous just to opt right into the Appeals Modernization Act. What they should do is have an expert trained in the law do a review of their file and make that determination for them. Knowing how to navigate that game, so to speak, is important.